Count 1 is dismissed.
This case opens with what seems like a routine courtroom proceeding, but within seconds, it spirals into something far more intense and deeply personal. What starts as procedural, dismissals, scheduling, and standard courtroom formalities quickly transforms into a high-stakes confrontation between truth, addiction, and judicial responsibility. At the center of it all is April Fleming, a defendant whose situation is about to shift from legal scrutiny to a matter of life and death. And presiding over it is Judge Simpson, who isn't just focused on the law, he's watching for something deeper: behavior, honesty, and risk. What makes this case immediately gripping is the unpredictability. There's no dramatic accusation yet, no explosive evidence introduced. But the tension is already building beneath the surface. The judge's tone, and the pacing of the dialogue, even the subtle interruptions, they all signal that something is off. And then comes the turning point. A question that changes everything. Were you huffing on Zoom? From that moment forward, this is no longer just about a case file. It becomes about credibility, accountability, and survival. Because in this courtroom, one wrong answer doesn't just affect the outcome of a case, it could determine whether someone walks out alive. And as we move forward, pay close attention to how quickly the narrative shifts from denial to confrontation to a full breakdown of trust.
Okay. Defendant is referred to probation for pre-sentence investigation and recommendation. Sentencing in this matter will be January 14th, 2025, 26, 9 a.m. Bond will continue.
Thank you. Thank you, Your Honor.
Thank you. Yeah, thank you. Court does call the case People versus April Fleming.
Ashley Felton. People. Good morning. Assistant Public Defender Warren Ms. Fleming. Ms. Fleming, state your name for the record.
Sorry.
State your name.
April Joy Fleming.
Your Honor, I am asking for hopefully one last adjournment. We've been adjourning for medical records. We did get some medical records. Are waiting for records from Trinity Health. Hopefully I can get that mitigation over to the people and come to
Ms. Fleming?
Yes.
Were you huffing on Zoom?
I'm sorry?
This is the moment where everything cracks open. The judge doesn't ease into the issue, he goes straight for it. That direct question, were you huffing on Zoom, is not casual. It signals that the court has already observed something concerning, possibly even alarming. And legally, this matters more than people realize. When a defendant appears in court, especially via Zoom, they are still under the court's supervision. Any behavior suggesting substance abuse during proceedings can be interpreted as a violation of bond conditions, depending on the terms. But beyond the legal implications, there's something even more critical happening here. The judge is testing credibility in real time. Notice how quickly the defendant denies it without hesitation. But the judge doesn't back off. He presses. Why? Because in courtroom dynamics, the consistency is everything. The moment a defendant's story starts to shift or feel uncertain, it raises red flags, not just about the current issue, but about everything they've said before. And here's the bigger question for viewers. If you were in her position, would you admit it immediately or try to deny it and hope it goes unnoticed? Because in this courtroom, that split-second decision is about to define everything that follows.
Were you huffing?
No, I was not.
Are you sure?
Yes.
So if it was reported to me by two people that you were, they wouldn't be telling the truth?
I don't understand what you mean. Was I huffing when?
Today.
Today? No.
Where do you live?
I live at Chittister Place Apartments.
How long will it take you to get here?
I don't have a ride or anything. I don't know. To get there today?
Yeah, today. We saw you doing something you probably shouldn't have been doing.
What do you mean, sir?
Were you huffing?
Was I huffing just now? Like on camera? No.
Okay, today off camera, on camera, you've been huffing?
No.
Not at all?
No.
So if you came down here and I sent you over for a test, everything's going to come back negative?
Yes.
Now the judge shifts from questioning to verification, and this is where the legal pressure intensifies. When he mentions sending her for a test, he's not just making a suggestion. He's laying out a potential evidentiary move. If she comes in and fails that test, it becomes documented proof of substance use, something that can directly impact bond status, sentencing considerations, and even future credibility in court. But notice the defendant's response. She doubles down. Everything's going to come back negative. That's a bold claim, especially given the judge's visible skepticism. And this is where things get dangerous, not just legally, but strategically. Because if that statement turns out to be false, it's no longer just about substance use. It becomes about deception in court. Judges don't just evaluate facts, they evaluate people. When they assess behavior, tone, consistency. And right now, Judge Simpson is building a mental profile. Hesitation, denial, uncertainty. All of it adds up. This moment also raises a critical issue. The court's authority doesn't stop at the courtroom door. If the judge orders her to appear for testing, failing to comply could escalate things even further. So the question becomes, does she fully understand the position she's in, or is she already too deep into panic to think clearly?
You will?
Yeah.
Okay, you're going to need to find a ride. I'm going to need you down here.
Okay, sir. I don't know how I could get there.
Miss Fleming, I'm gonna give you a call, okay?
Okay.
Thank you.
Thank you.
And counsel.
Ashley Feltus for the people. Good. Public Defender Lauren Perny on behalf of Miss Fleming. Say your name for the record, please.
Keep fun.
All right. Well, thank you for coming down. Miss Fleming, I'm going to ask you again.
I did. I was.
You did what?
I huffed.
You were huffing. Yeah.
I'm sorry. I made a mistake.
Why weren't you? Why were you lying to me when?
I panicked. I just panicked. And I'm so sorry. I'm really, really sorry.
Ma'am, how frequently are you doing this? I mean, are you doing that every day?
Sometimes.
I mean, you're going to end up dying.
Can you give me
I
another
mean,
chance today, please?
Is that what you're trying to do? Are
No,
you trying to kill yourself?
no. I'm sorry. I just.
Okay, so, but how long have you been doing this?
I don't know. I've tried it off and on for a year or so.
Have you thought that you might need to get into some type of treatment or something? Have you?
I need to.
But you haven't done that.
I guess I haven't had anything like this happen. I plan on getting in touch with.
Who are you going to get into? You don't even know.
Huh?
You don't even know who you're going to get in touch with.
Well, I know I have to speak to.
Well, I do. I will say Miss Fleming does go to therapy at Huron Valley Consultants.
Yeah.
as I've stated, we've been working on getting those medical records. I have reviewed some of those medical records. It indicates they do talk, and Ms. Fleming's on methadone. We're still in the methadone program. So I do know, I will say that there are entries that they've had these types of conversations about her past use. So I think it's something that Ms. Fleming knows that she deals with.
Yeah.
Have you told them that you're huffing?
No.
This exchange exposes a critical gap, not just in behavior, but in treatment. The defendant is in therapy, she's on methadone, she has a medical team, but she hasn't disclosed one of the most dangerous aspects of her current behavior to the very people who are supposed to help her. And from a legal standpoint, this matters more than it might seem. Courts often rely on treatment programs as part of a defendant's release conditions. But for those programs to work, they depend on full transparency. If a defendant withholds key information, like active substance abuse, it undermines the entire system. The judge recognizes this immediately, because now it's not just about whether she's using, it's about whether her current support structure is even capable of addressing the real problem. And if it's not, then releasing her back into that environment becomes a risk. This also highlights a harsh reality. Addiction doesn't operate on logic. Even when help is available, even when systems are in place, denial and avoidance can override everything. So now the court faces a difficult question. Do you give her another chance to seek help voluntarily, or intervene more forcefully to ensure she gets it?
I know I have to. I plan on speaking to my counselor today.
When's the next time you see your therapist?
I can see him tomorrow morning.
Okay, so Ms. Fleming, here's what you got to understand. For me, when you tell me that you have an appointment, when you tell me all these things, it becomes hard for me to believe whether or not you're telling me the truth.
I understand that.
And that's because I asked you a series of times when you were on Zoom.
I freaked out. I should have said the exact truth. And I'm so sorry, Judge Simpson. Please give me a chance today, please.
Well, Ms. Feltus, you want to say something?
I do, Your Honor. Ms. APA Cook was able to review the YouTube footage, and we shared with Ms. Kearney a screenshot that did show the defendant with the canister in her hand. I recognize that canister to be what I commonly refer to as dust off or computer cleaner, a type of compressed air. I'm very familiar with this drug, and I know that any time that you use it, it can cause instant death.
Yep.
This is a drug that is extremely dangerous, and the way that this is being ingested can lead to long-term issues as well as immediate death. The brain can die every time you do this.
This is one of the most critical moments in the entire hearing. The prosecutor steps in, not with aggression, but with urgency. And the shift in tone is immediate. This is no longer framed as a violation or misconduct. It's framed as a life-threatening situation. The mention of computer cleaner or compressed air, often referred to as huffing, carries serious medical risks. We're talking about substances that can cause sudden cardiac arrest, brain damage, even instant death. And what makes it more dangerous is how unpredictable it is. There's no safe threshold. But what stands out here is the prosecutor's approach. Instead of pushing for punishment, she advocates for intervention, specifically a bond change with release to treatment. That's a significant move. It shows that even the prosecution sees this as a health crisis, not just a legal issue. And yet, there's tension. Because while treatment sounds like the ideal solution, it also requires trust. Trust that the defendant will comply, engage, and follow through. So now the courtroom is balancing two competing priorities: compassion and control. And the judge has to decide which one takes precedence.
I think it's clear the defendant's very scared. I think it's clear that she wants to change. She wants to stop using. I really want to see her again, Your Honor. I'm very worried that we're not going to see her again. I truly want the court to hear that this coming in from a place of compassion and concern, not a place of bond violation. This coming from a place for the people of actual concern. We will not see her. I am requesting that the court consider bond change with a release to treatment for her to get some help. But I do know that my experience with this drug and all the education I have surrounding drugs in general leads me to believe this is an extremely risky behavior. I ask the court to consider a bond change.
Please, Your Honor, please.
Sure.
I do know Miss Fleming does have a medical team around her. She sees her primary care doctor consistently. As I stated, she is in therapy. I think everyone's concern for Miss Fleming is warranted, especially the circumstances that this arose out of. I'm happy to work with her and get information to the people in the court if the court allows her to stay out of custody. Obviously, if she's in custody, that will take place too. I'm just asking that the court consider letting us work on that while she's out of
Please,
custody.
please.
She does have some medical issues that, and that's partially why she sees her doctor so consistently. This is an old retail fraud. I do, it's this case, I don't believe has anything to do with her use or anything like that. I just asked for
Well,
a chance.
it
to
might
ask
though,
them.
because if she's been using for off and on, as she's indicated, a year, this offense is in June of this year.
I mean, I don't know exactly how long I've been using it. It's been for some months now. I don't know if it's been a year exactly.
Okay, Ms. Fleming, here's how I know you're an addict. You tell me one thing, and then when all of a sudden that doesn't seem like that goes your way, you change your story. You did that in rather rapid shot fashion when you were on Zoom.
I'm so sorry.
No, Miss Fleming, sometimes things happen for a reason, and not all of them we like what happens, but they happen for a reason. And maybe it also goes to what Ms. Feltes said.
Please keep me out of custody today. Please, Judge Simpson, please. I'm begging you.
You can't stop.
I am stopping. I'm done. I promise. I
And
promise
here's
with
my
everything
problem,
in
Ms.
me.
Fleming. Ms. Fleming, here's my problem. You've already lied to me today, repeatedly.
This is where the judge draws a hard line. Up until now, there's been questioning, concern, even moments of empathy. But here, the focus shifts to accountability. The repetition of the word repeatedly is deliberate. It emphasizes a pattern, not just a mistake. In courtroom dynamics, credibility is everything. Once it's damaged, it's incredibly difficult to restore, especially within the same hearing. And for Judge Simpson, that loss of trust becomes the central issue. Not just the substance use, not just the risk, but the inability to rely on what the defendant says. But here's where it gets more complex. The defendant is clearly emotional, apologizing, pleading, promising change. And that raises a difficult question. How do you distinguish between genuine remorse and reactive desperation? Because judges have seen both. Look, they've heard promises before. They've seen outcomes. And when the stakes involve potential death, the margin for error disappears. So this moment isn't just about punishment. It's about risk assessment. The judge is asking himself, if I let her go, what are the chances she survives until the next hearing? That's the weight of this decision.
Repeatedly.
I am so sorry. I am so sorry. I got here as soon as you said, please to come down. I got right on the bus and I came
It
here.
was either going to be, and I think you understood, if you didn't come down, we were going to come and get you because there was going to be a bench warrant.
Okay. I think you're scaring me straight.
No, I don't think I have. Certainly not yet. But I'm going to let you know, if you think for 1 minute that I'm going to sit here when I know what I know at this point and have you die on my watch, and I haven't used what tools I have to try to make sure that you stay alive, you're sadly mistaken.
Please don't take me in today, Judge Simpson. Please, I'm begging you. Please, please, everything in me, please. Please give me one more chance, please. Please, Judge Simpson.
And I will add, Your Honor, Ms. Fleming was honest with me when I spoke with her. I think she understands the reality of the situation.
Anything else you want to tell me?
Just that I'm going to tell you the truth from here on out. I swear on everything in me. I swear on everything in me, Judge Simpson. I swear on everything in me. And I voted for you.
Doing about the 65 other thousand, but thank you, I guess. You're not dying on my watch, not tonight.
I'm not going to die
I'm
tonight,
done.
please.
I'm done listening. Listen to me now.
Okay.
You're not going to die on my watch. I can't trust you. I don't know what therapeutic routine you have, what you have surrounding you that I can safely let you out. Because whatever you're doing at this point, you do it, you go home and you're huffing.
I won't,
Yeah, I know. You're going to tell me I won't do it. You're going to tell me that all that
please, Judge
stuff.
Simpson, please.
Miss Fleming, I've heard it all before. And then the next thing I know, before we even get to your case again, guess what? I'm online reading about your obituary, and I'm not doing it. I'm just not doing it. If they can get the information, I'll take a look at it and I'll potentially reconsider. I'll set a review of her bond on December 22nd, 2005 at 9 o'clock. But at this time, her bond is revoked, defendant's remanded.
I'm arrested? Oh my God.
Get somebody down.
May I appear for Zoom? Wait for that.
Pardon? Yes.
Thank you.
Yeah, I was going to say that.
Thank you.
Yes.
And just like that, the decision is made. The bond is revoked and the defendant is taken into custody. On the surface, it may seem harsh, but when you break it down, it's a decision rooted in prevention, not punishment. Judge Simpson makes his reasoning clear earlier. He cannot risk her dying on his watch. That statement carries both legal and ethical weight. Judges have a duty not only to uphold the law, but to ensure the safety of individuals under their jurisdiction, especially when clear risks are present. By remanding her into custody, the court is effectively removing her from an environment where she has access to harmful substances and placing her in a controlled setting where intervention is possible. It's a drastic step, but in this context, it's also a protective one. This case highlights a broader issue within the justice system, the intersection of addiction and accountability. When does personal choice become a public concern? And when does the court step in to override that choice for someone's own safety? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.